stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome back to Administrative Static. Before jumping into another topic, I wanted to remind our listeners that we are in the midst of our King George III prize competition. So if any of you have not yet cast your ballots for the worst offender of civil liberties in 2022, take a look. We're down to the Sour 16. We are trying to coalesce the elitist 8. The 8 worst bureaucrats in terms of offending civil liberties last year. And we need your votes to figure out who those folks are. So you can go to our website at nclalegal.org to cast your votes, or you can look for us on Twitter at NCLA Legal or on Facebook as well. And go and take a look at some of these matchups. John, I cast my vote. So there's 8 different matchups, so you can decide. You can cast 8 different votes for which of the various matchups in the various matchups, which of the bureaucrats you want to see go forward to the next round. And I have to tell you, it's sort of satisfying to cast these votes. And one of the votes that I have been casting consistently throughout this process involves a certain Richard Cordray, who it just so happens that NCLA has filed a lawsuit against Richard Cordray this past week. The name of the case is Mackinac Center for Public Policy v. U.S. Department of Education. Miguel Cardona, Secretary of Education, in his official capacity, and Richard Cordray, who's the COO of the student loan programs or student financial aid programs, and he's also sued in his official capacity. And NCLA's client here is the Mackinac Center for Public Policy, which is a Michigan-based public policy organization. And John, you and I know them because in addition to the sort of think tank public policy side of what they do, they also do public interest litigation.
Pat Wright.
Pat Wright, exactly. I think has filed some amicus briefs in support of some of our cases and vice versa. And if not, I'm sure we will in the future because they're involved in some of the same kinds of things that we are. The Venn diagram doesn't overlap 100%, but certainly some of the kinds of things that they're interested in dovetail with some of the kind of things that we're interested in. And one of those is the problem with this student loan forgiveness that's been going on. But you may recall, John, at oral argument at the Supreme Court, Solicitor General Elizabeth Preligar said, well, no one's challenging the ability of the Secretary of Education to delay the ability of these students to pay back their principal and interest.
And now you're going to make her regret it.
Well, it was wrong when she said it because the amicus brief that NCLA filed on her own behalf in that case in the Supreme Court pointed out that the delay in payments was also illegal, and that for the administration to point to the delay and say, well, look, the delay is okay, so we can just cancel it, that logic was flawed because the delay was also illegal. But either she didn't read our amicus brief, or she didn't want to encourage the justices to do so. But there's something else that our case on behalf of the Mackinac Center has in common with this other one, and that is the standing issue. As we pointed out in our amicus brief in the Supreme Court case, and I keep saying case, there's really 2 cases at the Supreme Court that are, for all intents and purposes, the same underlying issue.
Issues.
Yeah. But one of them is Brown v. Department of Education, and the other one is states of Missouri and Nebraska and Iowa and Kansas and Arkansas and South Carolina against the Department of Education. But the issue is in those cases is whether or not the Biden administration's effort to cancel $500 billion worth of student loan debt is constitutional. And I think there's fairly wide consensus that it's unconstitutional what they're doing. And you could hear that in the oral argument. Where I think that there's more dispute, John, is whether anyone has standing to challenge that. And so what we had said in our amicus brief was, hey, there's another basis for standing that hasn't been asserted by the parties here. But the interesting thing about standing is it doesn't matter. A lot of arguments, if you don't assert them, they're gone. That's not true with standing. The court has an independent obligation to determine its own jurisdiction, and standing is part of that. And so we told the justices, look, the states do have standing in this case. And the reason they have standing is because of the Public Service Loan Forgiveness Program. And the Public Service Loan Forgiveness Program is one that Congress set up in 2007. I'm going to oversimplify, but essentially what the program says is if you make 10 consecutive years of student loan payments, 120 monthly payments in a row, then your student loan debt will be forgiven. Well, if you have a sizable amount of student loan debt, that can be a very attractive incentive for you to go work in the nonprofit sector instead of in the for-profit sector. And the nonprofit sector includes state government. And so what we told the Supreme Court in our amicus brief is, hey, these states all employ people who are taking advantage of the Public Service Loan Forgiveness Program. If the public service, or what the government's doing in terms of forgiving the $500 billion of debt radically undercuts the effectiveness and the ability to use the Public Service Loan Forgiveness Program to attract talent. Therefore, these states are all injured as beneficiaries of the Public Service Loan Forgiveness Program. And in fact, John, there was a District of D.C. district court case in which the American Bar Association had brought suit about the Public Service Loan Forgiveness Program because they were left out as, I guess, not the right kind of nonprofit organization to benefit from it. And they lost on the merits, but they were found to have standing there. So we think that's a pretty good precedent for standing. Well, we are using the exact same theory of standing on behalf of the Mackinac Center to go after what's going on here with the payment and interest pause. And so we're hoping that maybe this theory of standing will finally get a hearing, because we use this in our own case on behalf of the Cato Institute, where we filed to oppose the $500 billion worth of student loan debt forgiveness in Kansas. And the judge just hasn't ruled on that. There's no stay. There just is no action.
The Supreme Court has this. I'll wait and see.
Yeah, and you see that happen. And John knows I was on my soapbox about this a little bit earlier this week. And so I don't know if we have enough time for this show for me to get up back on that soapbox again. But we see this happen way too often, that judges look, there's no reason why the judge can't rule. There's a pending motion.
Well, Mark,
yeah.
I will say this. I think that judges control their docket, and it always happens. Sure. We always complain about it. But here's the problem. The Supreme Court says we're not going to take cases because we're letting them percolate. And then the district courts say, well, this is kind of on the Supreme Court docket. There's no percolation going on. So it's frozen. On one end, you can't get it to the Supreme Court. On the other end, they're not making the decisions. I mean, that, I think, is a legitimate complaint that they're not talking to each other.
Yeah, that's a very good way. It's the pointing fingers, right, at each other. And I thought pointing fingers was stale, but I guess maybe that's just for Mick Jagger. In any event, we believe that there's a very good basis for standing for a group like the Mackinac Center for Public Policy. They have employed in the past employees who have taken advantage of the Public Service Loan Forgiveness Program. I believe they currently employ folks, and they certainly intend to employ folks in the future who take advantage of the Public Service Loan Forgiveness Program. But if you have $500 billion worth of loan forgiveness take place, then that will absolutely undercut the incentive for anybody to work for 10 years for Mackinac in order to get their student loans forgiven. That's a real harm. That's a competitive harm, and it ignores the fact that Congress is the one that put the Public Service Loan Forgiveness Program in place. When Congress has forgiven student loan debt or put programs in place to forgive student loan debt, there have been criteria that have gone along with that. You had to do something to get the debt forgiveness. Here, you had to work for a public service organization for 10 years. Not the same one. You could work for a few different ones, but right. you have to put together 10 years worth of working for public service entities in order to get this. And the Biden administration and Secretary Cardona and Mr. Cordray have just blown right through those statutory requirements and have set up their own.
And the Trump administration before it. This has been going on a while.
Well, absolutely. And we'll get to that a little bit in the next segment in terms of what exactly has happened with the pause. And I think we talked about this before. We had Shang Li on the program, and we talked a little bit when we filed the amicus brief about our concerns with the payments in both principal and interest, and how that did, as John just said, begin under the Trump administration. But it really began with Congress, and so we'll jump into that in the next segment. But what I wanted to leave folks with here, in this segment, is just the fact that this is not some exotic theory of standing. This isn't some new theory of standing that we're trying to get anyone to buy into. This is a sort of standard issue, vanilla, competitive injury standing, that you have a program that you're the beneficiary of, and someone is coming along and taking that away from you. Well, that's a harm, and that's what you need to have standing. And therefore, we think that the Mackinac Center for Public Policy has standing to sue in the Eastern District of Michigan over what's happening with this student loan payment and interest pause. Likewise, we think that the state of Missouri, the state of Nebraska, Kansas, Iowa, Arkansas, and South Carolina have standing at the U.S. Supreme Court to complain about the $500 billion worth of student loan debt forgiveness that is being litigated over there. So we'll be back with more on this new lawsuit right after this. But just don't let anybody try to tell you that no one has the ability to sue over this student loan debt issue, because they do. He's John Vecchione. I'm Mark Chenoweth, and you're listening to Administrative Static. We're talking about a lawsuit that the New Civil Liberties Alliance has filed earlier this week against the U.S. Department of Education Secretary Miguel Cardona, and the COO of the student loan area at the department, Richard Cordray. Richard Cordray's name may sound familiar. He ran unsuccessfully for governor of Ohio. Before that, he was the first director of the Consumer Financial Protection Bureau and was unlawfully appointed to that position by President Obama. So he has a long and distinguished career of administrative things that NCLA would object to. I guess I'll just put it that way.
And the Supreme Court found that. That's not just Mark's, that's not just like his commentary.
That's right. Well, if I'm being precise, they found that someone else appointed on that exact same day was not recess appointed because the Congress was not in recess. Well, since he was also recess appointed that day, he was also unlawfully appointed. And once the Noel Canning decision came down, the CFPB didn't fight the fact that Richard Cordray was also unlawfully recess appointed. They just got President Obama to fix that. But in any event, the nefariousness that Richard Cordray is up to now has to do with a pause on student loan payments, both the principal and interest payments that students have to make. And what began as a perfectly lawful thing became unlawful, as we often see, John, when it went from being legislative action to being administrative action. Because at the almost from the very onset of the lockdown and the pandemic, we had Congress jump into action. So I think that our last day in the office, if I remember right, John, might have been March 17th of 2020, something like that, whatever that Friday was. And then basically by the end of that month, and I don't know the exact date, if it was the 31st or something, but Congress had passed the CARES Act in order to provide relief for folks. And one of the things that was part of that law was the temporary pause on evictions. There was a temporary moratorium on evictions that was statutory, but only in federally subsidized housing. But one of the other things was a pause on payments for any federally held student loans, but that it was limited to a period of 6 months. So it expired on September 30th of 2020. And at that time, under the terms of the statute, students would have had to resume their student loan payments. So this was just a temporary pause. And by the way, it wasn't a mandatory pause. You could continue to make payments if you wanted to. I don't have any data on how many people did. I assume it was more than zero. But I assume that the vast majority of folks took advantage of the pause and said, "Oh, you don't want me to make a student loan payment? Okay, I have other and better uses for that money to enhance my disposable income. I will take advantage." Well, so what happens in August of 2020 then, when that payment pause when the expiration is looming for that payment pause? Well, the Department of Education stepped in and extended that pause from September 30th to December 31st. And actually, if you go all the way back, even before the CARES Act was passed, like less than a week before that, the Secretary had said, "Hey, we're going to pause these student loan payments." There wasn't any particular authority cited for that, but that was overtaken by events because Congress jumped in. Congress passed a statute. Before really the Secretary had done anything early on, you had statutory authority to do exactly what the Secretary of Education had said that she was going to do for the next 6 months. The problem is when that 6 month interval expired, there wasn't really a good lawful basis, and none was really given for extending that pause. Now, President Trump had indicated that he wanted to do that, so you could try to base it in some sort of inherent executive authority in the president, but that's not a strong basis for, this isn't some sort of commander-in-chief power or something like that. This is an area that traditionally is regulated by Congress. So, and then in December of 2020, there was an additional extension made through January 31st of 2021. And I think the idea there was not just to kick the can down the road, but to give a little breathing space for the incoming administration so that it could decide what it wanted to do. Well, you may not be surprised to hear that the incoming administration likewise wanted to extend the pause on student loan payments, both the interest and the principal payments. And so it did so, and it did so 6 more times. So we have a total of 8 extensions. And this most recent one, John, is an extension that goes until after the Supreme Court's decision in the student loan forgiveness cases. But one of the problems with that is they're not deciding in those cases the constitutionality of this issue, of this pause. So it's almost as if the department is saying, and they haven't said this, so I don't want to overstate this, but it's almost as if they're saying, well, we'll see what the Supreme Court does. If they let us forgive it permanently, great. If they don't let us forgive it permanently, well, maybe we'll do another payment and interest pause extension. So we thought it was important to get out in front of that, get this lawsuit filed in the Eastern District of Michigan, and put the Department of Education on notice that these are unlawful extensions and that they don't have statutory authority for this. Some of the arguments for why they don't have the authority are very similar to the arguments that are being made on the merits in the Supreme Court case. So, for example, the HEROES Act has been used, but what the HEROES Act says is that you can only do this, you can only modify student loan payments if you need to do so in order to ensure that a student is not made worse off with respect to the financial assistance that they're getting. Well, at the time that the first extension was made, there was a statutory pause in place. Because there was a statutory pause in place, I would posit, and we say in the lawsuit, no one could have been worse off with respect to their loans than they were before the pandemic. They were all better off because they were in the midst of having a pause in place.
A legal pause. By the people who are allowed to spend money and not spend money, right?
Exactly. It went through both houses of Congress. So you had your bicameralism. It was signed by the president. You had your presentment. It was all copacetic. And you may not like it. You may think it's bad policy. And one of the reasons you might think it's bad policy is you might think that's going to be a runaway train that no one's going to be able to stop. And you know what? You might be right about that, John. But at least procedurally, it was a valid statutory extension. But to then rely on the HEROES Act to say, oh well, now that this pause is in place, we can just sort of indefinitely keep doing these extensions, and that we need to do these extensions because now one of the things that really floors me is they say, well, because these extensions have been in place, students have gotten out of the habit of making these payments, so it's going to be really hard for them to make payments. In other words, they've probably put themselves in with car payments or housing payments or something.
They've gotten used to it.
They're assuming that they have more disposable income than they really have. And so it's going to be a real belt tightening for them when they have to start resuming the student loan payments. And I'm sure that's true, but that's not a valid reason under the statute. That's not connected to the pandemic. That's not connected to the national emergency. That's connected to the bad policy that the administration has put into effect by doing 6 more extensions of the payment and interest loan. The cost of this is $5 billion a month. And so now that we're 30 months in, John, this is over $150 billion. That's with a B, $150 billion that it's cost the Treasury in order to put this off. And that's an appropriation. And so one of the arguments that we make in this case, this is a violation of the Appropriations Clause. Only Congress has the power to appropriate. You can't appropriate like this just by extending a congressionally passed deadline. We also argue that under the Property Clause, that Congress is the one that has the power to distribute the property of the United States. And so if you want to think of this debt as property that belongs to the United States government, again, it's Congress that has the right to dispose of that. The executive doesn't have the ability to just indefinitely push that off. And you might say, well, of the first extension, it was just a short extension, and we saw this in the nationwide eviction moratorium, right, where the Supreme Court didn't go back and unwind the previous extensions that had taken place, even though those were all unlawful. But at some point, it said this is enough. Congress has to be the one to extend it any further, and I think that's also true here, and probably what the Supreme Court will say if this case makes it all the way up to the Supreme Court. Hopefully it's what the Eastern District of Michigan will say, looking at the Alabama Realtors case. It'll say, we've been down this road before, and you can't just endlessly extend this, and Congress has to be the one to implement any more extensions. Now, I don't know that we're going to win any popularity contests with this case, John. I'm sure there's a lot of students out there.
Not with people under 35.
People that have student loans to pay. But, there may be some folks out there who think, why should I, as someone who didn't go to college or as someone who paid off their loans, have to subsidize the cost for these other folks who chose to take these loans on? No one forced these loans on them. Why should I be the one that through my tax dollars effectively is paying this $150 billion?
And again, it goes back to Congress. Congress can do this. If there's a lot of opposition, they're perfectly okay to pass this. They're allowed to do what they want with the public money. That's why they have a Congress.
That's right. That's why Congress has the power of the purse. But you know who doesn't have the power of the purse? The Department of Education and Richard Cordray. So, I think that this lawsuit may come as a rude awakening. As you said earlier, John, Solicitor General Preligar, maybe she should be careful what she wishes for, because we've delivered to the federal government on a silver platter a lawsuit explaining why what they're doing is completely illegal. And hopefully we can convince the federal district court that that's the case. And I think that this will be a good opportunity to rein in the runaway administrative state yet again. You've been listening to Administrative Static. Thanks for being with us. Look forward to having you with us next week.